Opinion against David Chaytor and others.
Mr. Fleming, with the agreement of all parties and the Court being satisfied that it's in the interests of justice to do so, I make the following order lifting reporting restrictions. Pursuant to Section 37, subsection 5 of the Criminal Procedure and Investigations Act 1996, the prohibition in Section 37(1) shall not apply to 1. Any written report or any radio or television broadcasting of an oral report by a journalist of the submissions before the court or the judgment of the court. 2. Any radio or television broadcasting of A, my pronouncement of this order, and any other pronouncement that I make at this stage, and B, the first 5 minutes of the opening submissions made by Mr. Fleming for the appellants and Lord Panic for the respondent. This order is made on the understanding that the reporting will be accurate and responsible. If in the course of the hearing any counsel considers that any matter should be made subject to reporting restrictions, it will be open to him to make an application to that effect. The only other pronouncement I make at this stage is that after considering the papers, the Court has decided that this is a proper case to grant each appellant permission to appeal.
Lord, I'm grateful. Lord, in this appeal, I had written application, but in this appeal, I appear with my London friend, Mr. Julian Knowles, to represent Mr. Chaytor and Mr. Devine. My London friend, Mr. Fitzgerald, appears together with Joe Middleton on a pro bono basis for Mr. Morley, and Rebecca Troller also attends today on a pro bono basis on behalf of Mr. Devine. For the Crown, Lord Panic, Lewis Mabley and James Segan appear, and Lord Hanningfield has been given permission by the Court to make written submissions only, and submissions have been put before the Court dated the 15th of October 2010. Lord, could I start with a few opening remarks to set the scene? At the outset, could I emphasise that which I would not normally even mention? Lord, although this is an application, or was an application for permission in this appeal, we all proceed on the basis that the case raises important issues of principle. Indeed, Mr. Justice Saunders emphasised at paragraph 3.4 of his judgment that if the point had not been raised by the former MPs, he would have raised it himself. It is also a case without direct precedent. So far as we are aware, these are the first criminal prosecutions of members of the House of Commons in relation either to a statement made in or to Parliament or its delegates, or based on a member's dealings with Parliament for over 300 years. These proceedings have been brought and conducted against an extremely adverse, even hostile media and political background, and all those involved in representing the former MPs accept that the arguments are difficult and novel. But we submit they are important arguments, and it may be some time before this Court, our highest court, again has the opportunity to consider the reach of parliamentary privilege, particularly the privilege in Article 9 of the Bill of Rights, outside perhaps more straightforward examples of statements made by an MP or a member of the House of Lords in the course of debate carried on in the Chamber. My Lord, I also wish to emphasise as firmly as I can on behalf of these former MPs that this is not and never has been an attempt to take them above or outside the law. The former MPs do not submit at all that they are above the law or join issue with the familiar statement, "Be you never so high, the law is above you." These are proceedings to ensure that the allegations against them are dealt with by the correct law, the law of Parliament. And insofar as it is necessary to use the word court at all, proceedings to ensure that the allegations are determined before the correct court, namely the High Court of Parliament. We submit that it is in Parliament, and only in Parliament, that their statements made to Parliament can be questioned and impugned. As we note in paragraphs 7 to 12 of our grounds of appeal, the House has the power to punish. It has the power to recover any monies wrongly claimed, and is well capable of investigating allegations, including allegations of dishonesty made against its members. the investigation and determination would be carried out either by its committees or remitted to the Office of the Parliamentary Commissioner for Standards or some other mechanism to be determined by the House. The former MPs, of course, also accept that the privilege or privileges they seek to invoke are Parliament's and not theirs. The privileges attach to Parliament, not to its members, no matter how distinguished, no matter how humble. But the privilege protecting statements made in the course of proceedings in Parliament is a privilege that cannot be waived by an individual MP, hence the need for the additional section in the 1996 Defamation Act. And it may be that Parliament itself cannot waive the privilege. And could I refer the Court to the letter from the Clerk of the Parliaments at Volume 5 of the Court's papers at tab 63. A letter from the Clerk of the Parliaments in the House of Lords, dated the 4th of March 2010, and in the third paragraph it reads, "Thus parliamentary privilege is based in statute. Neither House has power in the absence of explicit statutory authority to waive parliamentary privilege because neither House has power by resolution to overturn statute, nor do individual members have the power in the absence of explicit statutory authority to waive parliamentary privilege." And then the example of section 13 is given. Lord, and even if the privilege could be waived, so far as we are aware, there has been no resolution of the House of Commons to that effect. True it is, as observed by Mr. Justice Saunders and by the Court of Appeal in their judgments, that we make these submissions without support from the officers of the House, and indeed comments made and actions taken by those officers, including the then Commissioner for Standards and Privileges, have been less than supportive. We address those comments in our grounds of appeal, and my friend Mr. Fitzgerald in particular will return to them in the course of his submissions. Lord, the Court of Appeal has certified a single question of law of general public importance. Lord, I won't read that into the record. Our broad submission is that the criminal charges levelled against the appellants necessarily involve questioning or impugning, taking those words from Article 9, or examining, discussing, or adjudging, taking the words from Blackstone, proceedings in Parliament. Not looking at Article 9 because the statements and claims made by them are themselves proceedings in Parliament. There's a suggestion that that's part of our case, but because they were made or submitted in the course of proceedings in Parliament. The reference to statements themselves being proceedings in Parliament comes from a 2003 decision of the then Parliamentary Commissioner for Standards, relied on in judgments below and by my learned friend, when dealing with a complaint in relation to Mr. Michael Trend, MP. If I give the Court the reference, it's Volume 5, tab 50, at pages 6 and 7. So when dealing with that observation by the then Commissioner, we say that either he is wrong or they are, with respect, just views. There is no analysis or reasoning and no explanation as to how he reached his conclusion. Well, could I start then by saying it's necessary to understand how the allowances system fits into the scheme of things within Parliament. And this is one of the few paragraphs of our grounds of appeal that I'd like to read and comment on, and this is paragraph 22. The expenses scheme, we say in Roman 1, was entirely created and is wholly administered by Parliament for parliamentarians. And missing a few words, the scheme, including payments in respect of allowances and expenses claims and the submission of such claims, forms part of Parliament's internal procedures. My Lord, we there refer for the history to our paragraph 51, We also rely on paragraphs 50 to 56 of our grounds of appeal and pages 82 to 115 of the appendix.
Could you give those pages again?
Yes, my Lord. It's pages 82 to 115 of the appendix. Those pages are mainly extracts from the Green Book as it evolved during the course of the years covered by the charges against the appellants. In addition, there is one other document that we've referred to below and we draw your attention to, and that's the concordance of resolutions on the salaries allowances topic. And that's was produced in 2006, and it's volume 5, tab 51. And it provides a useful list of the actions and decisions of the House of Commons in this area. Well, the only reason I refer to it at this early stage is it shows, if it's necessary to show it, that the entire scheme is created by and approved by the full House through resolutions made by it or delegated down to its committees. So that's our 22 Roman 1. For Roman 2, the scheme relates to and is ancillary to, but nevertheless an essential part of, the discharge of parliamentary functions. The purpose of the scheme is to reimburse MPs for the expenses, and then these words we emphasise, necessarily incurred in order to perform their functions as MPs. In this respect, allegations of MPs' dishonesty in relation to their expenses claims, which fall within proceedings in Parliament, can be distinguished from allegations of, for instance, MPs stealing property within the precincts of Parliament which do not and would not be ordinary crimes punishable in the court. And clearly the reference to ordinary crimes is important, and I'll pick that up in a few minutes. And thirdly, members of Parliament are only able to benefit from the scheme by virtue of their status as MPs. Or to put that another way, the operation of the expenses scheme, particularly when claims are made by MPs, involves the MPs acting in their capacity as MPs, or to use the phrase that appears in some of the cases, they are acting as such. But what is clear, we submit, perhaps beyond argument, is that the entire scheme is a creation of the House of Commons. The Fees Office, which itself is part of the Department of Resources in the House of Commons, is a creation of and acts on behalf of the House of Commons. And the expenses system is ancillary to, and only exists to be ancillary to, the primary principal function of the House of Commons. That's the creation. We also say that the administration of the scheme is also entirely a matter for the House of Commons. This extends, therefore, beyond its creation to its regulation, and it would include its enforcement. Now, although the vast majority of claims will be processed by the Fees Office on behalf of Parliament, as Parliament's delegate, if there is any dispute about individual claims, they can go to the Speaker, or from him or her to the Members' Estimate Committee, and none of this appears to be in dispute. So that's the broad structure. The scheme, therefore, invites the submission of claim forms, which are presented by the MPs to Parliament. In the case of the appellants, they're presented, of course, to the House of Commons. It is these completed forms, and the Court will have come across the description of the forms dealing with particularly allowances. It's the form ACA2 and documents attached to ACA2, which provides the information which is furnished to Parliament, using now the language of Section 17 of the Theft Act, for the purpose of making allowances or expenses claims. Lords, we have an example of ACA2 in the appendix. And it's the last document after the extracts from the Green Book. And it's a member's claim form, ACA2, and indeed it's this document that's referred to in the various charges levelled against the former MPs. You'll see, my lords, that the claim details tell the reader you can only claim for costs you have actually paid, additional expenses wholly, exclusively and necessarily incurred to enable you to stay overnight away from your only or main home, etc. Then there are details, and then there's a declaration. I confirm that I incurred these costs wholly, exclusively and necessarily to enable me to stay overnight away from my only or main home for the purpose of performing my duties as a Member of Parliament. We say that that is a clear statement to Parliament. So we submit that it is important first to understand and correctly categorise the allowances or expenses system and determine whether or not it falls within proceedings in Parliament, and then secondly, correctly understand on a principled basis how the impugned actions of the former MPs fall within that scheme. Well, the argument for the Crown and the judgments below, particularly on Article 9 of the Bill of Rights, are based on three main strands or three main pillars. First, that the charges amount to allegations of, quote, ordinary crime, end quote, and parliamentary privilege has never extended to cover such matters. First strand. Second, claiming expenses is not an MP's core parliamentary function. And then linked to that core parliamentary function point, the allowances/expenses scheme does not form part of proceedings in Parliament within Article 9. That's the way it runs. And in my oral submissions, I intend to address those three topics in that order, seeking to persuade the Court that the Crown's argument and the judgments below are wrong. My focus will firmly be on Article 9, but in the knowledge and understanding that Article 9 is not the only privilege in play, Mr. Fitzgerald will address the Court on that wider privilege, essentially paragraphs 70 to 97 of the grounds of appeal, and also whether or not Parliament has waived its exclusive jurisdiction to deal with disciplinary matters. Well, that leaves from the language of the statute one other phrase, and that is, ought not to be impeached or questioned in any court or place out of Parliament. Lord, it appears to be common ground that this is not an issue in this case. If the prosecutions go ahead, there will necessarily be a questioning of the proceedings, including the truthfulness of the statement I've just read to you from ACA 2. And we deal with this topic in paragraphs 64 to 68 of our grounds of appeal, and don't take it further. I note, however, on reading those paragraphs, noted this morning, that there is one case that perhaps should have been in the bundle, which was in the Court's bundle below, and it's the Church of Scientology of California case. And I've put additional copies before the Court this morning. It isn't relevant to any submissions I make because it's confined only to impugned or questioned. But if your Lordships are looking at Pepper and Hart and Preble, they both refer to and approve the Church of Scientology case, reported at 1972, 1 Queen's Bench at page 522, and the cross-references, it's Pepper and Hart at 639 C to E, and Preble at page 333 G, and the particular passage from the judgment is at pages 529 just below G to 530 F. And it's in this judgment, my Lord, that you have a recent or more recent reference to Blackstone's commentaries on what is meant by questioning and impugning. Lord, I don't take that any further, but thought you should have the missing case. So, my Lord, could I turn to our first topic, and that's ordinary crime? The Court of Appeal refers to and relies on the reference to an ordinary crime in the judgment of Mr. Justice Stephen in Bradlaugh and Gossett. And you find the reference in paragraph 29 of the Court of Appeal judgment. Bradlaugh and Gossett is at volume 1, tab 10, and I will come to it in a few moments, if I may, on another part of the judgment. So it's volume 1, tab 10. The Court of Appeal then refers repeatedly through its judgment to one of two phrases: criminal, ordinary crime, or criminal activities or criminal behaviour by members in the House. That's the phrase. And it's paragraphs 31, 32, 39, 81 and 82. And in the Crown's response to this appeal at, for example, paragraph 13 and 14. So it's a mantra that goes through the judgments and through the submissions. And we deal with this topic at paragraphs 13 to 18 of our grounds of appeal. My Lord, our submissions proceed on the basis that Article 9 of the Bill of Rights, or any other privilege of Parliament, does not protect a member of the House from investigation or protection from a crime of violence. An example is in the bundle. I won't take you to it. It's volume 3, tab 25, the well-known, infamous 19th century case of John Bellingham, who was convicted of the murder of the then Prime Minister Spencer Perceval, and the murder took place near the door by which members entered the lobby of the House of Commons. This was a crime of violence within the building rather than in the chamber itself. If the shot had been fired by an MP rather than by a disgruntled member of the public, we accept that parliamentary privilege would not apply, and we have no need to argue to the contrary. It is not submitted, it is not necessary to submit that this crime, or your Lordships may recall, Mr. Ron Brown's deliberate damage to the mace in the 1980s, or Bernadette Devlin, later Bernadette McAlliskey's assault on the then Home Secretary, Reginald Maudling, were protected by parliamentary privilege. I take those two examples because they both occurred inside the chamber. So we proceed on the basis that a member of Parliament cannot, whether inside or outside Parliament, assault anyone, including the officials in the Fees Office, cannot kill, rape, blow up Parliament, steal from a colleague or from the members' bar, or steal a picture from the wall and avoid criminal court prosecution.
So we're going beyond crimes of violence to theft.
To theft and all, the category of ordinary crimes. And my Lord, I've included there stealing a picture from the wall, as that was an example put to me by the Court of Appeal. The other examples are obvious, particularly blow up Parliament. Now, these we submit, we describe them as ordinary crimes, but listing them and others, and the list could almost be endless, merely serves to identify another list of otherwise ordinary crimes where the criminal law does not apply, but the law or regulation of Parliament does. If there were not such other crimes to be listed, then the privilege identified in Article 9 of the Bill of Rights would be severely restricted or curtailed or would disappear. The task is not to seek a distinction between ordinary crimes and crimes which are extraordinary in the sense that they are so closely connected to the discharge of core parliamentary functions that privilege applies, which is the contrast suggested by the Crown in paragraph 13 of their response. So it's not a contrast between ordinary crimes and this group of extraordinary crimes, but we submit to consider whether what would otherwise be an ordinary crime is not to be the subject of prosecution in the criminal courts because of the circumstances in which the act or omission occurred. The Crown, in paragraph 14 of its response, refers to a statement by the House of Commons Committee of Privileges in 1831 that it was, quote, established generally that privilege is not claimable for any indictable offence. But that statement, we submit, has to be seen in its proper context and is clearly concerned with a time when members asserted a general privilege to be immune from civil, or it appears, criminal action merely because they were MPs. So if they were committing alleged crimes 100 miles from Parliament, then they claim to be immune. This is not the claim in this appeal. Could I then now take you to Bradlaugh and Gossett at Volume 1, Tab 10, where this line appears in the judgment of Mr. Justice Stevens. What you'll see from the head note the House of Commons is not subject to the control of Her Majesty's courts in its administration of that part of the statute law which has relation to its internal procedures only. What is said is done within its walls cannot be inquired into in a court of law, and you will see in the third paragraph that what was being considered there was whether an action would lie against the Sergeant-at-Arms of the House of Commons for excluding a member from the House in obedience to a resolution of the House directing him to do so, nor will the court grant an injunction to restrain that officer from using necessary force to carry out the order of the House. The judgments after the judgment of Lord Coleridge, the then Chief Justice, which are referred to in our arguments on exclusive jurisdiction, then Justice Matthew on page 277 concurs, and then we have the judgment of Mr. Justice Stephen on page 277. And the particular passage which produces the reference to ordinary crime is on page 283. And in the middle of the page, 283, in the second paragraph, there's a reference to Burdett and Abbott, and then a little further on, the only force which comes in question in this case is such force as any private man might employ to prevent a trespass on his land. I know of no authority for the proposition that an ordinary crime committed in the House of Commons would be withdrawn from the ordinary course of criminal justice. And then there's reference immediately to the Sir John Eliot case in the 17th century. Or if you take the last two words on that page...
So if the Sergeant-at-Arms had used unreasonable force on that occasion, what would be the position?
Lord, I'm not sure that they actually discuss it in the case, because the part of the judgment begins at 282, final paragraph. It seemed, as I read it, and I haven't gone back to that part of it, that the Sergeant of the Arms would lose his immunity if he went beyond strictly justifiable force, because that would not be consistent with the instruction from the House. In other words, he'd lose his protection given to him by the House. If I recall, it was dealt with by the Lord Chief Justice at page 276, but I can't put my finger on it precisely. Yes, it's the protection, and this is what distinguishes the officer from the MP. It's the officer is protected by the limits of the instruction that's given to him. It's in the middle of page 276. Lord, going back to the judgment of Mr. Justice Stephen, at the foot of the page, the last two words, this case, that's the Eliot case, is a great leading authority, memorable on many grounds for the proposition that nothing said in Parliament by a member as such, that's the words I was referring to, can be treated as an offence by the ordinary courts. The House of Lords carefully avoided deciding the question whether the Court of King's Bench could try a member for an assault on the Speaker of the House. Could I also take your Lordship to the Wasson case? This is volume 3, tab 35.
So do we get any assistance as to what an ordinary crime is,
No,
page
no,
283?
we don't know. That's the source of what has become, as I say, a main strand of the argument, and I will then, I hope, extend it a bit further. Ex parte Watson is volume 3, tab 35. It should be the penultimate tab in that binder. And that's a conspiracy case, but you have at page 576 the judgment of the then Chief Justice Coburn. The top of page 576, it's clear that statements made by members of either House of Parliament in their places in the House, though they might be untrue to their knowledge, could not be made the foundation of civil or criminal proceedings, however injurious they might be to the interest of a third person, and a conspiracy to make such statements would not make the persons guilty of it amenable to the criminal law. It's the first part, really, the first 4 lines, which is picked up by Mr. Justice Blackburn towards the end, beginning, "I perfectly agree with my Lord as to what the substance of the information is, and when the House is sitting and statements are made in either House of Parliament, the member making them is not amenable to the criminal law. It's quite clear that no indictment will lie for making them, nor for the conspiracy or agreement to make them, even though the statements be false to the knowledge of the person making them." And Mr. Justice Lush, to like effect, ending with the sentence, "I am clearly of the opinion that we ought not to allow it to be doubted for a moment that the motives or intentions of members of either House cannot be inquired into by criminal proceedings with respect to anything they may do or say in the House."
When the phrase "in the House" is used, that suggests to me that they're talking about the chamber. But I suppose one could extend that to things said in committee rooms.
Yes.
Are you asking us to extend the phrase "in the House" beyond
Yes.
those places?
Yes, those judicial statements are clear. They're talking in the House by members in their place in the House. We submit that the privilege applies to whenever there are proceedings in Parliament, and that's the language of Article 9. In that case, they were not dealing with the factual circumstances we're faced with here. And I'll come to this, of course, when dealing with proceedings in Parliament.
But it's not unknown for parliamentary committees or subcommittees to take evidence outside the House, even in Brussels, for example. It would be slightly surprising if a completely different regime applied according to whether that took place in the House or outside.
Still be proceedings in Parliament, even if Parliament has now travelled to Brussels, like diplomatic privileges, travelling with the committee. Words, this is really a series of stages, and this is the easy stage, inside the chamber. Words spoken or documents produced in the course of debates or proceedings in Parliament, whether in the chamber, before parliamentary committees, or in other proceedings in Parliament, could themselves be criminal. That's the point I'm trying to emphasise at this stage, or could themselves provide evidence of criminality. But to use the words of Mr. Justice Stephen, cannot be treated as an offence in the ordinary courts. So what I'm focusing on at this stage is whether the words ordinary crimes is a helpful term. And when we were asked questions in the Court of Appeal, one of the topics came up as to what other crimes could be committed by speaking in the House or submitting a document in the House or document to a committee apart from criminal libel or sedition.
Could Parliament try a Member of Parliament for criminal libel?
No.
They couldn't?
No. I'll come to this in a moment. Your Lordship has touched a very important point, that there is a distinction between criminal allegations and breaches of the rules and standards of the House. So the House, in the example you have given, may have cause to investigate, indeed take to a determination and punishment, behaviour that could amount to criminal libel. But it is not trying that person for criminal libel. on our analysis. It may be that there's a higher level of argument, and because they are a court, unlike some parliaments, then they could act as a criminal court, but that's not our submission at all. And indeed, it's fundamentally important to distinguish the criminal process and the investigatory and punitive process of the House. But I'll, of course, come back to that when dealing with...
But here, on the facts here, they could they or not?
Yes, they wouldn't be investigating and trying these 4 MPs or the other 2, or the 2 members of the House of Lords, for an offence under Section 17 of the Theft Act. They would be dealing with them for breach of the privileges or standards of the House and acting contrary to the rules. In other words, these 3 former MPs would be accused of and investigated for deceiving the House. And Lord,
so the ingredients of the parliamentary offence would be different, or potentially different, would they,
yes,
from the ingredients of the offence tried in the ordinary courts?
It could well include elements of the criminal process, but that's entirely a matter for Parliament. If Parliament includes in the allegation that you have been dishonest, taking the particular charges, it is not for us to say that Parliament can't do that. But what they would be doing is investigating a breach of their rules. They would not be charging somebody with an offence contrary to Section 17. Well, could I just follow this through by examples? I say what happened in the Court of Appeal is on my feet, Steve my learned friend Lord Panic on his feet, we're trying to think of a couple of additional examples that could arise by words or documents. And we have finalised over the weekend examples, and they're no more than that, of crimes committed by making oral or written statements, which should be by your side on your side table. It's headed Applicants' Examples of Crimes Committed by Making Oral or Written Statements. And we start with the obvious one of criminal libel contrary to common law. Secondly, sedition or treason contrary to common law, or the Criminal Libel Act and the Treason Act. Then we move into corruption and bribery, bringing in the 2010 Bribery Act. Then official secrets offences, and we now start giving your Lordship some examples. For example, if during a debate on security policy, a former Foreign Office Minister reveals details about the workings of MI6, he would, save for parliamentary privilege, commit an offence under Section 5. Then there are offences of dishonesty, and we've given examples: conspiracy to defraud, contrary to common law. For example, 2 MPs agreed to make untrue speeches in the course of proceedings in Parliament, questioning the financial stability in a bank in order to profit from a drop in its share prices. False accounting, which is our case, and we've put that in as the next example. Moving to a particularly stark example, because it links in to the Register of Members' Interest, which is a point I'll come to later. Section 397 of the Financial Services and Markets Act 2000, making a false or misleading statement which induces a person to make an investment. And the example we provide, which could be embellished, of course, an MP, during proceedings in Parliament, deliberately talks up a company in which he holds shares, intending to increase the share price, and he will not have disclosed that interest in the Register of Members' Interests. Then offences under 1 to 4 of the Fraud Act: fraud by false representation, fraud by failing to disclose information, particularly important, fraud by abuse of position. And, for example, during a debate on a new airport, or in the course of related proceedings in Parliament, and I'm assuming these are all uncontroversially in the chamber or in a relevant committee, so no dispute about proceedings in Parliament. An MP supports the project, declaring he has no personal interest, and in fact he owns land which will rise in value as a result. Save for parliamentary privilege, this would be fraud. Then blackmail, we set out the example, and we go on to other topics, rather getting carried away with ourselves at this point. Glorification or encouragement of terrorism, false statements contrary to the Perjury Act, perverting the course of justice, acts likely to stir up racial hatred, which is not that unlikely. See the example we put in brackets. And then public order offences, particularly, you can think of so many examples of public order offences. The reason that we produce the list is first of all, to have a proper answer to a question that may be posed by the court that we didn't have in the Court of Appeal, but also to submit that these are ordinary crimes. There's no difference in substance between the crimes we've listed there and murder, rape, pillage, or blowing up the house. So the difficulty...
Corruption and bribery, you say, and provided always it's corruption and bribery in connection with the parliamentarian's life as a parliamentarian, is simply not properly triable as in a criminal court?
It would depend, my lord. Under the case of Greenway, to which I'll come, the conclusion by Mr. Justice Buckley was that the offence of bribery, corruption in that case, was complete without any need to refer to parliamentary proceedings. So if that can be done, yes. But if the entire actus reus, if I'm using the right phrase, is committed in the course of proceedings, then it has to be immune. Because, or not. I mean, this is why this is so important. Your Lordship's Milady has the opportunity to say that this is a very narrow protection, and it only covers certain types of crimes which would otherwise be prosecuted, or it covers all crimes, no matter what the categorization, unless Parliament waives, can waive, the immunity. Because otherwise, my next stage is you start drawing lines. At the moment, judicially, we're falling on the wrong side of a line. We say the line is in the wrong place, but it could be on analysis in A, B, and C position. We seek to persuade the court that it should be in A position, the Court of Appeal having held it's in B or whatever it is.
I don't know if you've looked at the American law on this, but the United States Supreme Court has decided that bribery isn't covered by the speech or debate clause of the US Constitution.
That was, Lord, the only case I've looked at is Brewster. Brewster, an important case in English common law terms because of the distinction it draws between the American constitutional position of the courts and the peculiar position in the history of the world of our Parliament, which has a status of a court. And it's drawn in part of the speech. We have Brewster in the cases. Yes. Lord, I haven't taken... That was the source of the distinction. Bribery and corruption is a particularly interesting area because of an example we put into the papers. If I could just touch on it now. You have, without doubt, proceedings. So you have a committee, or the House, doesn't matter, but let's assume for the moment a committee, where Mr. A sits in the committee to make it more interesting as chairman of the committee. And he has a relationship with a Mr. or Mrs. B outside the committee. A Mr. or Mrs. B have a dodgy expenses claim that he or she wants to pass through to receive £20,000. An agreement is made between an outside MP and an inside MP. I mean, outside this committee, I'm talking about the Members' Estimate Committee. That agreement is then made. The claim form is put in. It's a bogus claim form. It's passed to the committee by the Fees Office. The chairman of the committee encourages everybody on the committee to say this is a very good claim, we must pay it, and then shares the 20,000 or 10,000 with the first MP. Now, a clear conspiracy to commit crime. Can what happens inside the committee be questioned or impugned? Or is the conspiracy completed outside Parliament, which is the Greenway analysis? Or can you draw a distinction between the person putting in the statement to the committee and the person adjudicating on the statement in the committee? It's that kind of example that troubles those who represent the former MPs, and we present to the court with due humility as to what the answer is for that kind of example. So what we end up with is where do you draw the lines, as I've said, what are proceedings in Parliament, how narrow or how broad is the scope of the privilege. And if what is said or written takes place in the course of proceedings, without any doubt, but now clear its proceedings, are the contents ever protected when they show or are evidence of what would otherwise fall within a list of criminal offences. In particular, are the contents of such oral or written statements ever protected, where they show or evidence of criminal acts of dishonesty with which we are concerned. The Court of Appeal identified in paragraph 11 of its judgment what it describes as the essential question. And could I take you to that, because the greatest of respect to the constitution of that court, they began to fall into error at that point. In short, this is after discussing the Elliott's case and what became, later we will see, is the decision in, the analysis in Holdsworth. In short, the courts had no jurisdiction over any words spoken in Parliament by a Member of Parliament, but the jurisdiction to consider criminal offences committed in the House remained. So that's the first sentence. The essential question in these appeals is whether this principle has been altered by subsequent developments, and in particular by Article 9 of the Bill of Rights. So those two sentences really start what follows. It is not a part of our case that the criminal courts have no jurisdiction to consider, and we add the word, any criminal offences committed in the House. So that's not been our case. There was, as I've perhaps hinted at already, a moment of hesitation before Mr. Justice Saunders, when I alone for Mr. Chaytor, expressed doubt as to whether the courts had concluded that all offences of violence, including assault on the Speaker, were triable in a criminal court. And that was merely a reference to Mr. Justice Stevens in Bradlaugh and Gossett at page 284 that I've just shown you, where it says, but the House of Lords in the Sir John Eliot case carefully avoided deciding the question whether the Court of King's Bench could try a member for an assault on the Speaker of the House. So I was taking Mr. Justice Stevens rather than Holdsworth law of England. But that's the hesitation. The doubt was not repeated before the Court of Appeal as not being necessary, and the appellant's case is and only is that the criminal courts have no jurisdiction over any words spoken or documents submitted in the course of proceedings in Parliament by a Member of Parliament. So, again, the questions begin to emerge. Does the privilege cover only words spoken, or does it extend to the written word? We say the answer to that must be obvious. It must include the written word if it includes the spoken word. And secondly, if what is considered does fall within the description, words spoken or documents submitted in the course of proceedings in Parliament by a Member of Parliament, do the criminal courts have jurisdiction where the words spoken or documents submitted are evidence of criminal offences of dishonesty by the responsible MP? So I spent perhaps too long on dealing with ordinary crime, but the court may appreciate why I am focusing on it, because this became a very important part of the judgments below. Linked to this question of ordinary crime is another theme, perhaps touched on in part by the question from Lord Clerk. Parliament is ill-equipped to investigate criminal investigations, and that's referred to in paragraph 47 of the Court of Appeal's judgment, when they say this: the police, the prosecuting authorities and the courts are better equipped and more experienced than Parliament in the investigation and examination of criminal allegations. And there are similar observations by Mr. Justice Buckley in Greenway. If I could give your lordships the reference. I'll come to Greenway in a moment for another reason. So it's Greenway at volume 3, tab 26, at page 363. But this is to understand, we submit, the impact or effect of parliamentary privilege under Article 9, which is really now repeating the answer I gave to Lord Clerk. If what is said or done in those circumstances, that is, in the course of proceedings in Parliament, by a Member of Parliament, offends the rules, practices and standards of the House, this is different. It is not a question of investigating criminal allegations or criminal charges or criminal activities but the matter of the House itself investigating breaches of its own rules or standards.
Mr. Pemming,
Yeah.
if you take an example of fraud or whatever it is
Yeah.
committed in the chamber and so on,
Yeah.
does the person commit the offence, but the courts have no right, have no jurisdiction to try him, or does he only commit an offence against Parliament?
Well, no, analytically, it could be either. It could be both, in fact. He could fit the description of the ingredients of the offence.
I'm assuming he does.
Yes, then the criminal allegation could be framed as the charges are here. And the criminal courts would either stay the proceedings because of privilege of Parliament, or, and the decisions are not entirely clear, they would decline jurisdiction on the basis that the conduct which forms the basis of the crime cannot itself be impugned or questioned.
But the answer to my lord must be that the crime is committed
Yes.
if Parliament can waive the privilege.
Yes, certainly. Yes. If there are circumstances in which Parliament can do that.
But it may not be a crime that can be adjudicated upon by Parliament.
Yes, that's what I'm trying to emphasise, that there's a suggestion that Parliament is ill-equipped to investigate crime. Well, yes, because it doesn't have a police force, hasn't a CPS. But that's not what it's doing. It's investigating and adjudicating and punishing in relation to breaches of its own rules. And it doesn't mean it can't do that job and do it well, but without supervision by the courts, because for the reason we've been discussing. It's clearly capable of conducting detailed and comprehensive investigations into the conduct of its members, and an allegation or complaint, because it may come from outside or in the press, that an honourable member has behaved dishonourably, has deceived the House, has lied to the House, has misused the allowances scheme, can be tried, for want of a better word, by a committee of the House, and more recently by the Commissioner for Standards and Privileges. In our grounds of appeal at footnote 12, on page, it's page 5 of my copy, paragraph 12, footnote 12. Your Lordships may well remember this. This is one of the many pieces of litigation in which Mr. Al-Fayed was involved. And he challenged a decision by the Parliamentary Commissioner for Standards, reported in 1998 at volume 3, tab 29. Just to paint the picture, what was being investigated was an allegation that a member of Parliament had taken a bribe of £2 million to assist in the takeover of the House of Fraser, or connected with that. And the Member of Parliament was the then serving Home Secretary. And there was a very detailed investigation into those allegations in which the former Home Secretary was exonerated. But that was carried out by the Commissioner for Standards with counsel, with accounting expert assistance, and there was an extensive investigation and some hearings. The most recent example is in yesterday's Times, Sunday Times front page, under the wonderful heading, Peer in Flat Scam Fined £125,000. The court may well have seen it, may not have seen it, when Baroness Udin is said, according to the Sunday Times, to have been suspended as a result of the House of Lords investigation with two other members of the House of Lords. What that shows, if it's right, is that the House of Lords, as with the House of Commons, is well capable of carrying out an investigation and imposing punishments and penalties, not the same as the criminal courts, because it is not the criminal court.
But it's also not the same offence. You have to identify some differently formulated offence, don't you? Formulated in accordance with some principle or rule laid down by Parliament. So that your clients may not be on your analysis above the law, but they are not susceptible to the law which everybody else is susceptible, but to some different law identified by Parliament, which may or may not amount to the same thing.
They would be accused of contempt of the House, particularised, and I don't have before me how the particularised charges were made against Baroness Udin, but they would be particularised to show that the ingredients of the contempt are deceiving the House by abusing the allowances system, and that would be particularised. But it wouldn't be in the Southwark Crown Court, it wouldn't be in the form of a charge. The general allegation would be contempt of the House. And we say there's nothing gracious of respect to the Court of Appeal in the better equipped to investigate point. Whether or not Parliament can or cannot investigate effectively does not determine whether or not statements, oral or written, were uttered in the course of proceedings in Parliament. If they were so uttered or otherwise form part of the proceedings, unless the House can, as a matter of law, and does as a matter of fact, and that's the House as a whole, can as a matter of law and does as a matter of fact waive the privilege, then it is a matter for Parliament alone. Before leaving this topic of ordinary crime, could I go to very briefly the Greenway case, because I see it's still relied on by my learned friend, and it's referred to in the judgments below. It's in volume 3, tab 26. This is a case that's only reported in a volume of public law and owes its reporting to an article by Professor Bradley. So it's in public law at page 356, so it's tab 26, and the report begins on the second page. And your Lordship will see on the first page that this was an allegation that a particular MP, Harry Greenway, was given air tickets as a reward for using his influence as a Member of Parliament in respect of an application for British nationality, an allegation which is perhaps familiar from other media claims. And Mr. Justice Buckley turns to the question of parliamentary privilege and then addresses it. We, in our grounds of appeal at paragraph 17, have said and submitted that this owes nothing, it doesn't assist the Crown at all, because it was held that the allegation owes nothing to any speech, debate, or proceedings in Parliament. But it still forms an important part of the Crown's weaponry, or at least did below. And the allegation there was bribery or corruption contrary to common law. Details of the allegations are set out. I've just mentioned a brief summary. In our paragraph 17, without taking you to it, we had set out a relevant passage from the speech of Lord Salmon into his own report, or after his own report, which was being discussed in the House. And you can see that being set out on page 361. And the quotations that we have added into our grounds of appeal, or the printed case, is on 361, when there's reference to the speech of Lord Salmon, two extracts ending with, "The crime of corruption is complete when the bribe is offered or given or solicited and taken." So that's where we ended our quote. What I should have added in is what follows. It is important to note that which Lord Salmon pointed out, namely that corruption is complete when the bribe is offered or given, solicited or taken, if, as is alleged here, a bribe is given and taken by a Member of Parliament to use his position dishonestly, that is to favour the briber as opposed to acting independently, and on the merits the crime is complete. It owes nothing to any speech, debate or proceedings in Parliament. Proof of the element of corruption in the transaction is another and quite separate consideration. Privilege might well prevent an inquiry by a court into parliamentary debates or proceedings. However, it is not a necessary ingredient of the crime that the bribe worked. A jury will usually be asked to infer corruption from the nature of and circumstances in which the gift was given. I cannot see that Article 9 in any way prevents that. Then there's reference to ex parte Wasson, and his lordship says this: assuming that decision to be correct, I cannot see that the reasoning would apply to alleged bribery, for the proof of which no reference to goings-on in Parliament would be necessary. Then there's reference to the Brewster case that I touched on earlier, and his lordship says this: if the receipt of the benefit and surrounding circumstances, including things done or not done outside the House and not forming part of parliamentary proceedings, are not sufficient for a jury to infer corruption, and a prosecution should not be launched, because the courts will certainly respect and uphold parliamentary privilege in respect of those matters covered by Article 9. So your lordship will see that when analysed, Mr. Justice Buckley's judgment, far from supporting the Crown, supports these appellants. And he was seeking to show and saying that the offence was committed outside Parliament.
Why, if that's right, couldn't you prosecute 2 MPs for conspiring outside Parliament, that one of them should make a false statement in the House?
Well, fortunately, I don't need to deal with that, but if the facts fit that description, then yes, and my A and B MP's example would fall, unless, and this is the difficulty, if the only evidence for that conspiracy is what is said in the House, let's assume there's no smoking gun outside the House, then what is said in the House, in the committee by MP B, could not be relied on either in the prosecution of MP A or in the prosecution of MP B. Indeed, we still take the position that the position of MP B is that he cannot be prosecuted.
Does conspiracy only amount to a crime if the object of the conspiracy is actually brought about? I think maybe that's okay.
No, that's again touched on by Mr. Justice Buckley. But could I leave that for my learned friend Mr. Fitzgerald, with greater expertise in criminal law than myself? But the important point to emphasise is if the prosecution requires what was said by MPB, then that could not be relied on. And that's the latter part of the analysis by Mr. Justice Buckley.
In such a case, could the defendant rely upon something he or somebody else did in Parliament as part of his defence?
Well, probably not. And that's the exact problem that arose when it came to the defamation proceedings that led to the amendment of the Defamation Act with the introduction of Section 13, because Mr. Hamilton, in that case, wanted to bring proceedings, but would rely on what was said in the House in his own defence or in his own claim, and that was held not possible without an amendment. But in the example your lordship's given, it has to be good for the goose, it's good for the gander, that if you can't refer to it, you can't refer to it.
But the consequence is that you stay the criminal proceedings.
Yeah, exactly. You either stay it or there's no jurisdiction. Those are the two approaches. It doesn't leave, as I keep emphasising, it doesn't leave the Member of Parliament immune. Because take the example I've just given you of A and B. If the material comes out into the public, and the Telegraph, the Sunday Times, or whatever, comes to the attention of the House, or is a specific allegation to the House, then the committees or the Commissioner for Standards can investigate that conspiracy inside and outside, because they would both be in contempt of the House. I'm sorry to keep emphasising, but sometimes it's easy to slip away from the essential part of the case. Could I turn to core parliamentary functions, having left now ordinary crime? Because the second part of the hurdle we have to overcome is that this is not part of core parliamentary activities, or not part of the MP's core parliamentary functions. And the Crown relied upon two authorities, and they are as follows: the Attorney General of Ceylon and de Oliveira, and Buchanan and Jennings. And they're dealt with in paragraph 19 of the Crown's response. The Crown also relies on the 1999 report of the Joint Committee on Parliamentary Privilege. Could I take that as a separate topic? Again, with great respect, care has to be taken with these judicial statements, which were not directed to the creation and operation of Parliament's internal expenses system. And when the Crown and the Court of Appeal both accept that the review by Sir Thomas Legge, the Legge review, to which I will refer, does fall within the internal proceedings of Parliament. And when dealing with the joint review in 1999, to which I'll come, there is, we say, no clear principled distinction between the creation and operation of the members' register of interests inside proceedings in Parliament and the members' allowance and expenses system as to its administration outside proceedings in Parliament. We deal with that in paragraphs 19 to 22 and 43 of our grounds of appeal. Could I turn then, first of all, to the Attorney General of Ceylon, again taking this very briefly. This is a case, Volume 1, Tab 8, Familiar Territory for the Court, a Privy Council case dealing with bribery and dealing with two phrases: in his capacity as such member, and also proceedings in Parliament. The Crown relies on the last few lines of page 120, the speech of the committee being given by Viscount Radcliffe. And so page 120, last few lines. Well, it's useful to read the whole of the last paragraph, but it's only the last few lines that are relied on. Could I pick it up in the middle of the last paragraph? The Privy Council is there dealing with proceedings in Parliament and also capacity as such. This is not the same question as that now before the Board, and there is no doubt that the proper meaning of the words proceedings in Parliament is influenced by the context in which they appear in Article 9 of the Bill of Rights. The answer given to that somewhat more limited question depends upon a very similar consideration of what circumstances and in what situations is a member of the House exercising his real or essential function as a member. So it's back to capacity as such. For given the proper anxiety of the House to confine its own or its members' privileges to the minimum infringement of the liberties of others, it is important to see that those privileges do not cover activities that are not squarely within a member's true function. But could I take you on to paragraph 121? If taken as read, the link between the top of 121 to the middle of the page, the most perhaps that can be said is that despite reluctance to treat a member's privilege as going beyond anything that is essential, it is generally recognised that it is impossible to regard his only proper functions as a member as being confined to what he does on the floor of the House. And you will then read on if you would. And then these last three lines after the Strauss debate can only be regarded as directly recognising that the privilege of Parliament extends beyond the activities of questioning, voting or debate. So the Board is setting the beginning and then moving on to say it's a very difficult question. It isn't just the debate, it isn't just being in a committee, contributing, it's much, much wider than that. So, and also, the Board, of course, was not there considering the issue that arises here as to whether or not a member's essential or real function includes his dealing with the House in his capacity as an MP, while claiming an allowance or expenses, so that he or she has the wherewithal to engage in the activities of questioning, voting or debate. And that's the whole purpose of the allowances scheme. The second case relied on by the Crown, the same bundle at tab 11, is Buchanan and Jennings.
Sorry, before you leave the case,
sorry.
What was the problem that they were addressing? It was
This
something that was not done in the House as such, but outside it?
The question was whether the member was acting in his capacity as such member. So it's in his capacity as such. The facts are set out in the top of page 104, my lord.
Yeah.
You'll see that there's an offer of a bribe, a gratification, if he would write to the minister withdrawing his application for the acquisition of the estate. And just above the holding, the first respondent's appeal to the Supreme Court of Ceylon was allowed on the ground that the gratification, wonderful word, was not offered to the member as an inducement for doing an act in his capacity as a member of the House of Representatives. So it was in what capacity was he being offered, and in what capacity did he receive? So, well, the second case is Buchanan and Jennings, again, a case with which you may or may not be familiar. This is a defamation case, as many of them are. And we say that this doesn't take the matter much further, because the board was essentially concerned with repetition outside the House of a statement protected by absolute privilege under Article 9 when made inside the House. So the board was focusing on and only concerned with whether or not the privilege should extend to cover a press release in which the Member of Parliament renewed his attack on the New Zealand Wool Board, including its senior official, Mr. Buchanan, or where the MP repeated outside Parliament what had been said inside by saying that he did not resile from his claim about the official's relationship. And you can see that in paragraphs 2 and 3. Indeed, this is a warning to all MPs. When you are asked, did you mean what you said in Parliament? Never say yes. and that's the essence of this judgment. But it's the repetition that's at the heart of it. And again, as with the Ceylon case, the board is not concerned with the scope of proceedings in Parliament when considering exchanges between a Member of Parliament and Parliament itself, or its committee or servants. And if a true function or core function or essential function is confined to debates or votes or participation in committee, it's difficult again to see how the register of members' interests or the leg report could be included. The judgment of Buchanan and Jennings is also relied on by the reference to, on page 123, to the 1909 report. Your Lordships will note that the Privy Council only refer to one part of the report and then go on to deal with parliamentary proceedings being televised and recorded. So it must be kept in mind that when my learned friend Lord Pannick picks up paragraphs of the Joint Committee's report, they have not all been endorsed by the Privy Council in Buchanan and Jennings. So, shall I then turn to paragraph 50 of our grounds of appeal? It's one of the other few paragraphs I wanted to read to the court. See where we've got to. It's on page 20. The allowances system forming the basis for the police investigation and the indictments against the applicants is an integral part of internal parliamentary life. It has no existence outside Parliament and there is no suggestion or allegation in the applicant's cases that any outside body, person or agency was involved, misled or deceived. The present expenses system was created, or at least authorised, by a parliamentary select committee entirely administered by a department of the House of Commons. The power to pay, administer and regulate expenses, MPs' expenses, rests solely on the authority of resolutions of the House. Analysis of the basis of the allowances system clearly demonstrates that it can properly be regarded as a matter intimately bound up with the working of Parliament as a legislative assembly. And that's our case. We invite this court to accept that submission as an accurate description of the allowances system, the allowances scheme. The Crown comes close to the appellants on this point, accepting at paragraph 24 of its response that, quote, submitting an expense form is linked to the performance of core parliamentary functions, in that the terms of the expenses scheme have been determined by Parliament. The schemes will require the submission to the claim form. Parliament has accepted that the payment of expenses and allowances will assist the MP to perform his core parliamentary functions, and the expenses claim arises out of the performance of parliamentary functions in the past.
Which paragraph was that?
Paragraph 24, my Lord,
Thank you.
of the Crown's
Yes, yes.
response. And in the same passage, the Crown, paragraphs 23 and 24, the Crown submits, and submission was accepted by the courts below, that it is necessary for the MP to be performing, quote, the essential functions of an MP, and so directly contributing to the ability of the House to perform its functions. That's paragraph 23, and then stating at paragraph 24.4 that, quote, the submission of the claim form for expenses is an act primarily concerned with the claiming of a sum of money for the personal benefit of the MP itself. And we submit in response with respect that that's a difficult argument to sustain. True it is that the privilege is for the benefit of the House, but the House can only act by the individual contributions of its MPs. Its only existence is either by its officers or by its officers and its MPs. The Crown submits that to claim expenses is not of itself to perform a core parliamentary function, but merely an administrative act carried out to obtain funds which may better equip the MP than to carry out his or her parliamentary functions. We submit that it is sufficient that the submission of the claim is inextricably linked or related to a core function, or alternatively, it is part or parcel of the MP's essential function as a working member of Parliament. I won't go through the case law to which my learned friends refer, save to mention one, because this can also be slightly taken out of context. In this part of the analysis by the Crown, at paragraph 20.4, the Crown refer to and rely on the judgment of the Lord Chancellor in Wellesley and the Duke of Beaufort. Can I take your Lordships, my lady, to that case at volume 3, tab 36. This is a decision in 1831 and the passage upon which my learned friend Lord Panic relies.
Sorry, could you give me the reference?
Yes, it's volume 3,
Yes.
tab 36. Decision of Wellesley and the Duke of Beaufort. And the passage from the Lord Chancellor's judgment, which begins on page 544, is at page 545, penultimate paragraphs. And this is the reference to wild and extravagant and groundless and inconsistent notions of privilege. If your Lordships, my lady, would read the paragraph beginning, but if anyone wishes to see, and then the reference to what happened in 1759,
Sorry, where is this?
It's on page 545, penultimate paragraph,
Right.
but if anyone wishes.
Thank you.
The particular passage relied upon by my learned friend, but at the same time saying these are not wild and extravagant and groundless claims by my clients. I won't read it all out. Your Lordships will see the passage, and then the reference in the beginning of the second paragraph to the action of trespass for breaking and entering a fishery was tried in the House of Commons to the lasting opprobrium of parliamentary privilege, to the scandal and disgrace of the House of Parliament. But this case has to be viewed in context as to what was going on. The claims about the reference to extravagant and groundless and inconsistent notions of privilege were comments made in the context of a claim by a member of the House of Commons who had carried off his infant daughter, who was a ward of court, from a place where she was kept and cared for. He took the child to a place which he refused to reveal. The court then issued proceedings committing him to prison for contempt in relation to his refusal to reveal where the ward of court was, and he claimed that he was immune from attachment by the privilege of Parliament. Just against those facts, it's not difficult to see why the Lord Chancellor made the remarks that he did.
So it was relying, they were relying on the mere fact of the attachment, coupled with the fact that he was a member.
Yes, yes.
That's all there was to it, was it?
That's all there was to it, that he could not be, the court had no jurisdiction to deal with him because he was a member of Parliament, even though it was in relation to his seizure of a ward of court outside Parliament. And as I recall, he wasn't represented. The court appointed Mr. Beams to act on his behalf. You'll see on the first page that this was a motion by Mr. Long Wesley, the father of the infant plaintiffs and now a prisoner in the custody of the Sergeant-at-Arms, for a contempt that the order of his commitment might be discharged on the ground that as a member of the House of Commons he was protected from attachment by the privilege of Parliament. So that's the context in which...
So you think it's not at all surprising that the Lord Chancellor should say that this was wild and extravagant?
Not at all. But not a helpful thing to say in two ways. First of all, it suggests that these are wild and extravagant claims, and they're clearly not, because all those who've been dealing with this case recognise that these are serious and difficult problems. But they are firmly based in the language of Article 9 of the Bill of Rights. And Article 9, which I'll eventually come to, deals with freedom of speech and debates or proceedings in Parliament. So it is contemplating a generous area of exclusion for questioning or impugning what happens in those circumstances. So there's also another passage in the same case at page 544. I think it's 544. Yes, Lord, it's the beginning of the judgment. 544, first paragraph under the name of the Lord Chancellor. If a court of law or of equity, upon due deliberation, entertains an opinion that a member of either House of Parliament has privilege of Parliament, that court is, in my judgment, bound to give him the benefit of his privilege, and to give it him with all its incidents, even although the House to which he belongs abandons it as a claim of right. For a court knows nothing judicially of what takes place in Parliament till what is there done becomes an act of the legislature. It's very firm and ringing words.
That's an intervention in the argument, isn't it?
Looks like it.
It's.
I think it is.
Yes.
Yeah. You're right, my lord. The judgment begins at the penultimate paragraph below, where he is exceedingly well pleased that I took the course that I saw fit to take. So, my lord, that's Wellesley and Beaufort.
What was John Wilkes prosecuted for? I notice one of the cases referred to is a case where he was given parliamentary privilege. Do you happen to know?
No, my lord, I'll make sure that I do by... It may be that that's in Erskine May, which I have in front of me. We'll find that out before this afternoon.
Can we go back to that passage at 544? It's a rather interesting explanation, just at the end of that little passage where he says, "For a court knows nothing judicially of what takes place in Parliament till what is done becomes an act of the legislature." Yeah. I suppose one might say that of things said or written in connection with the formulation of legislation, but it doesn't seem a very apt test if one's dealing with things of an administrative character.
Well, we have moved a long way in public law terms, and we've also got pepper and heart. We have moved a long way from that strict formulation. What is important is the words that add to that last line or precede that last line. It's what he's emphasizing is that this is an important privilege that is claimed by the defendant, it's claimed by the individual, as it can only be claimed by the individual. You rarely get the House claiming privileges. The House's officers may intervene, seeking to draw attention to Article 9, but the usual course is either in defamation proceedings or in criminal proceedings, as here. The claim is made by the individual. And what the Lord Chancellor was saying is that even if the House has abandoned it, then we still have to determine it. And that may not be the case if the House can formally waive, but at the moment what we have is the letter from the clerk to the House that it can't be waived, and on its face it's a letter that makes good sense.
Well, if it could have been waived, this would have been a very strong case of waiver, because there was actually a Committee of Privileges report concluding that his claim to be discharged from imprisonment by reason of privilege of Parliament ought not to be admitted.
Lord, I can think of many law claims of waiver. One would be if a member of Parliament in the committee says he knows he has a bomb or wants to kill somebody. In those circumstances, can he be prosecuted, or is it just going to be a disciplinary offence? That's when it comes to its sharpest point. Or if, as we get close to the 5th of November, it's said that there is some explosive in the House. And one has to, of course, keep that in mind. But what is important is if there is to be a waiver, it's by the whole House. It's not a waiver by an officer of the House. Well, for these reasons, we say, as we set out in our grounds of appeal, that picking up where we've got to, that ordinary crimes is not the touchstone. Core or essential functions, that if that is the touchstone, then the allowances scheme forms a part of the essential function of Parliament, which is what I'm mainly concerned with, and the submission of the claim form to the allowances scheme is sufficiently linked to the MP's core activities that both of those boxes are ticked. But that then begs the question of what is meant by proceedings in Parliament, which is the penultimate topic to which I turn.
Before you turn to that, you say that the box is ticked by the MP submitting the claim form.
Yes.
What if he submits the claim form in the full knowledge that he has not incurred the expenses and with a particular project in mind, his own enrichment for a particular purpose? Does that bring it sufficiently into association with the discharge of his functions of an MP?
Yes, Lord, that's a very interesting question, because now take my MP standing in the House, who is carrying out one of the descriptions of criminal activities in our schedule of crimes committed by oral or written statements. It should make no difference that he is or she is behaving dishonestly. He or she doesn't seek to be acting as such, as a parliamentarian, because the protection contemplates criminal proceedings. So it contemplates proceedings or allegations which are complete as to actus reus and mens rea. So it must contemplate the fraudulent as well as the honest MP, because the reason the protection is there is to deal with the fear of investigation. That's the chilling effect. It isn't to protect the dishonest MP, it's to ensure that those who speak or submit documents are not going to be the subject of investigation, or it's the very strange version of the knock on the door when the police come into Parliament. Now, the police come into Parliament, investigate what is going on, what is said, to investigate the papers, and also the concern, which is concern you may have seen referred to in the newspapers, that there has to be a fear, there is a fear that if this series of prosecutions continues, then it's an opportunity for rivals, for those who are political rivals, for those with a grudge or a grievance, to make an allegation of dishonesty. And because it's dishonesty, because it's ordinary crime, even though part of proceedings in Parliament, in come the criminal forces. So, my Lord, in answer to your question, if he intends the fraud, he is no different from the person who puts the documents in who is entirely innocent. That's our submission. Could I move to proceedings in Parliament? Lord, we address this centrally important issue in paragraphs 33 to 63 of our grounds of appeal, so devoting much written ink and paper to it, and we don't repeat the arguments there set out. The term itself is clearly an important term. It's repeated in section 6 of the Human Rights Act. So you're not a public authority, and you're engaged in proceedings in Parliament. What we say in paragraph 27 of our grounds of appeal, and here repeat, that the effect of Article 9 was in the last century summarised in the 1999 report of the Joint Committee on Parliamentary Privilege, and that's paragraph 38 of the parliamentary report, which is in volume 5, tab 49. And this is what they said at paragraph 38 of the report. In more precise legal language, that's Article 9, protects a person from legal liability for words spoken or things done in the course of, or for the purposes of, or incidental to any proceedings in Parliament. So it's in the course of, or for the purposes of, or incidental to any proceedings in Parliament. And we invite this court to adopt that description. As we make clear in paragraphs 33 and 34 of our grounds, the appellants accept that the primary focus or meaning of proceedings is the legislative process, the process by which the House acts in its collective capacity, so either in the chamber or in one of its committees. So it follows that there is no room for argument, nor should there be room, that proceedings in Parliament and the protection arising from Article 9 covers everything said, oral or written, in the chamber of the House or in its committees, wherever sitting, here or in Brussels. That's the easy area. What the case is about is whether or not, what this case is about, is whether or not the business of the House, its collective actions, here the administration and the management of the allowances scheme, it could be some other parliamentary scheme, can extend beyond that primary meaning. That's the collective actions of the House, and if so, how far does it extend? As I said a few minutes ago, Article 9 on its terms is not merely concerned with debates in the chamber. Even when formulated in 1688 or 1689, it refers to freedom of speech and debates or proceedings in Parliament. So we're looking at something beyond debates. The Court of Appeal, at paragraph 38 of its judgment, accepted that the protection of Article 9 is not confined to freedom of speech. and they take the McGuinness's application as the example, referring to a decision of the Speaker of the House. In paragraph 39, there is reference to the Al-Fayed case, which I've already mentioned, focusing on the responsibility of the Parliamentary Commissioner for Standards. The Al-Fayed case is at volume 3, tab 29. I won't take you to it, but the particular reference is 673D to F. And the Court of Appeal say below that the functions of the Committee of Standards and Privilege constituted part of the proceedings of the House, therefore clearly part of Article 9.
Where do we find that? In paragraph?
In paragraph 39 of the judgment of the Court of Appeal.
39, yes.
The functions of the Committee of Standards and Privilege constitute part of the proceedings of the House. Whilst your Lordships have that paragraph open, the last sentence of paragraph 39 is, as always with great respect, a non sequitur, or at least nothing to the point. Your Lordship, my lady, will see that it says, neither Ray McGuinness nor ex parte Al-Fayed suggests or implies any relaxation of the principle that a criminal offence committed by a Member of Parliament in Parliament itself is not justiciable in the criminal courts.
I had a difficulty following that proposition. Yes. Is the not superfluous?
I put a not question mark before justiciable. Yeah. Well, let's delete the not, which I've done earlier. But, so neither McGuinness nor ex parte Al-Fayed suggests or implies any relaxation of the principle that a criminal offence committed by a Member of the Parliament in Parliament itself is justiciable in the criminal courts. So what's being said there, and I had deleted the not when I went through the draft, is, I say a non sequitur or nothing to the point, because it begs the question as to whether a criminal offence is committed by a Member of Parliament in Parliament when he makes a statement, oral or written, taking the example to the Speaker in McGuinness or to the Commissioner for Standards in the Al-Fayed case. As we, could I move from 39 to perhaps for us one of the most interesting parts of the judgment, and we note in paragraph 24 of our grounds of appeal that if you go to paragraph 68 of its judgment, the Court of Appeal is also included in internal proceedings. And you'll see that the third sentence in 68, the leg review was, it seems to us, properly described as internal proceedings of the House, reflecting the way in which the House had decided to address what had become a notorious problem. Now, before I go to the last sentence, just if I may remind your Lordships that Sir Thomas Legge was appointed by the Speaker of the House of Commons and by the Members' Estimate Committee, and these are the terms of reference at volume 5, tab 60, to determine the validity of payments of the additional costs allowance, ACA, made to Members of Parliament during the period April 2004 to March 2009, and to recommend any repayments which MPs should make. That's the terms of reference. Sir Thomas Legge was not only appointed by Parliament, but he reported back to Parliament, thereby ensuring that all of his proceedings and his report are protected by parliamentary privilege. So here you have the Court of Appeal correctly in our submission accepting that these are internal proceedings of the House, and we submit it follows they are proceedings that fall within Article 9 of the Bill of Rights. But the last sentence of paragraph 68 is clearly correct, but it doesn't take the argument any further. This is what it says. It did not operate to bring the claims for expenses within the ambit of parliamentary privilege if, at the time when the claims were made, they did not fall within its ambit. So if the claims for expenses were not with the ambit before, then the mere existence of the later review would not give them a different colour. And again, with great respect, as we submit in our grounds of appeal, we agree. Not a point we seek to make, and we didn't try to make that point before the Court of Appeal. It's a terrible point. Also, as we note in paragraph 25, of greater importance, if it is accepted that the leg review falls within internal parliamentary proceedings and parliamentary privilege therefore applies, then the statements of MPs to the leg review must logically and sensibly also fall within those internal parliamentary proceedings, whether those statements are made orally or in writing. And if they so fall, they cannot be impugned or questioned in any other place. That must be the case if those statements are libellous, for example, in relation to an officer of the fees office or to describing a supplier as a dishonest whatever. So they're immune for that purpose, and they must also be immune for criminal purposes, and such as false accounting. And let me expand that. We've now got in place the review by Sir Thomas Legge, and he calls an MP to account to explain a claim for expenses, and in order to ensure that the gain already claimed is retained, dishonest papers are put in, or a particularly enthusiastic Member of Parliament decides that this would be a good opportunity to increase his claim and puts in a dishonest claim, including the statement, I certify that this is incurred only for the purposes, first of all, it was incurred, and for the purposes of my duties as an MP. And also we know from the Sir Thomas Legge's review that, as you would expect, he didn't act alone. He had 54 helpers, a supporting team of administrators, accountants, forensic accountants, auditors, etc. But it shouldn't make any difference to the analysis if the dishonest statements were only submitted to or considered by the 54. The documents are still being submitted to Sir Thomas Legge and through him to Parliament. But the fact that the claims by these former MPs were submitted to an official in the Fees Office rather than to the relevant committee direct, or to the Speaker or to the House in general sitting, is central to the Court of Appeal's reasoning. Can I take you to paragraph 75?
Paragraph 75
of the Court of Appeal.
Yeah. Could you at some point come back to the Legge report? Because I'd quite like to see how the remit was formulated and what properly fell within it.
Shall I deal with that before I make my point on it? It's the Legge report is at volume 5, tab 60.
Yeah.
Well, as you have that document open, could I show you one page which is also relevant? The opening page should be the Members' Estimate Committee. I hope this is... You have the title page, Review of Past ACA Payments, and then over the page, Members' Estimate Committee.
Yeah.
It's a useful place to find a description of what the Members' Estimate Committee does and its functions, and you'll see that it has a distinct hands-on role in relation to the allowances scheme. And on page 1 is the House of Commons Members' Estimate Committee response to Sir Thomas Legge's report. And at paragraph 2, that should be a sentence beginning, on the 23rd of November, we agreed.
Yeah.
Any sums recommended for repayment by Sir Thomas should be recovered from members, preferably voluntarily, but if necessarily by deduction from pay and allowances on the authority of a resolution of the House. This was, however, subject to members having the opportunity to show in an independent appeal process any special reasons why it would not be fair or equitable to require them to make the repayments. The Right Honourable Sir Paul Kennedy agreed to conduct the appeal process. The reason I mentioned that is that the introduction of the Right Honourable Sir Paul Kennedy is because the House recognised that the Thomas Legg review could not itself be challenged. So they created an internal appeal process.
And would the appeal process be covered by privilege as well?
Yes, and that's in the correspondence in the papers. We've referred to it in our grounds of appeal. I'll give your lordship the reference. The ACA review itself is described at page 4, and you'll see the review is addressed to the Speaker and to the Members' Estimate Committee of the House. And your lordship will see how he is appointed on the first page. And whilst we have this document open, it may be of assistance to see paragraph 2. The ACA system was deeply flawed. The rules were vague. MPs were themselves self-certifying as the propriety of their use of the allowance, etc. My learned friend Lord Panic relies on paragraph 8 as somehow assisting his argument, because it says, my review was excluded from dealing with issues under investigation before the 20th of July 2009 by the Parliamentary Commissioner for Standards or at any stage by the police, nor has it dealt with tax which falls to HM Customs and Excise. And then at page 7 there's reference to a small number of cases involving conflicted transactions where MPs use the ACA to buy or rent a second home from or have works to be done by a relative, business associate or employee. The use of the ACA in such circumstances also breached the requirements of propriety, and the view has been taken that in such cases the whole allowance ought to be repaid. That is in effect a summary of count 3 against David Chaytor. That he's accused of doing that, but dishonestly. That's the word added, of course. And then you'll see the background history of the ACA begins at page 9, and the only other... yes, my lord. Page 12 is a description of the fees office. And you will see that they are described in paragraph 27 not as civil servants, but servants of the House. And at page 14 is another passage relied on by my learned friend, other investigations and the exclusion of investigations by the Commissioner for Standards or by the police. And they are described in paragraph 44 as being taken out of his jurisdiction. But, Lord, I won't take you through the rest, but if your lordship, my lady, turn to page 16 onwards, there is a very helpful description of the interpretation of the rules, including the Green Book, the practice of the Fees Office, and at paragraphs 59 onwards, the fundamental principles to be applied. And at paragraph 68, they are summarised, taken in part from the Green Book. In short, MPs were thus personally required to ensure, and it was the duty of the Fees Office to help them ensure, that their use of the ACA throughout the review period was A, necessary for the performance of their parliamentary duties, in accordance with the Nolan principles, strictly in accordance with the rules governing the allowance, above reproach, took account of the need to obtain value for money, and avoided any appearance of benefit or subsidy to the MP. And you'll see it again in 69. These principles, taken together, clearly amount to at least the same general requirement of propriety as the House of Commons itself rightly expects and enforces. So the end result is the broad result is on page 25. You'll see that it said there were breach of principles. There were conflicted transactions which were described as being tainted at paragraph 86. And then individual conclusions and recommendations are set out in great detail in the body of the report. This is just a summary, but the broad result you can see on page 25. Lord Hope, does that answer your Lordship?
Thank you very much.
So going back to the point I was seeking to make is that if you have the leg review as being part of internal proceedings, then it shouldn't make any difference if the documents were being submitted by the MP direct to Sir Thomas Legge or to part of his bureaucracy. But the fact that these were submitted, in our case, to an official in the Fees Office is, as I say, central to the Court of Appeal's reasoning. Lordship's turn to page 75. I'm paragraph 75. I'm very sorry. This is the paragraph after the Court of Appeal has declined to address my example of increasing bureaucracy, and then say this: a claim for expenses is not submitted to any member of the House, nor even to the Speaker, or to the Lord Speaker, or to his or her office. It is submitted to an official in the Fees Office, and although that official is appointed by and is an agent of the House, he is not officiating in connection with the business carried on within the chamber or within a committee. He is merely carrying out an administrative task, albeit one mandated by the relevant House and one subject to the detailed rules approved by the House. So, Lord, we have here a surprising distinction, that there is, the answer may have been different if the claim for expenses had been submitted to another member of the House, or to the Speaker or Lord Speaker in the House of Lords, or to his or her office. But no, this is only submitted to an official of the Fees Office. Lord, that becomes increasingly important, and if you turn to paragraph 77, you have, after the Court of Appeal has dealt with the assault on the official and grabbing the money from the till, it would therefore be curious, this is the last sentence, if privilege were to apply to a member who defrauded the Fees Office by submitting a false claim for expenses to the very same official. Now, in paragraph 75, my Lord, the Court of Appeal is stating that the official in the Fees Office, although appointed by and an agent of the House, quote, is not officiating in connection with the business carried on within the chamber or within a committee. But if it is accepted that Article 9 proceedings extend to the business of the Commissioner for Standards, or to the review by Sir Thomas Legge, or the appeal process by Sir Paul Kennedy, then business carried on within the chamber or within the committee cannot logically, on a principal basis, be the touchstone. What we seek to achieve, my Lords and Lady, on behalf of the former MPs is some form of principled approach, accepting that it engages in a process of line drawing, but it reflects the relationship between a Member of Parliament and Parliament, of which he or she is a member. And it's for this reason that in paragraph 61 of our grounds of appeal, we attempted a structured approach which the Court of Appeal declined to address, and the declined to address in polite terms. In paragraph 74 of their judgment, it says this: while it may fairly be described as making a statement, the submission of a claim for expenses does not involve the member in question making a statement in or to either House or to a committee of either House. With very great respect, we beg to disagree and submit to the contrary in our grounds of appeal. The increasing bureaucracy example in our paragraph 61 is we submit a useful test as to the correct approach. And as we say in that paragraph, that if exactly the same statement had been made physically in the House or before a committee, an understanding of whether or not the statement would be privileged in those circumstances assists in determining, and these words we say are important, on a reasoned and principled basis, whether or not an identical statement made to the House as delegate should be treated differently. The original example, the first example, is in paragraph 61A, and your Lordship will see it's a fairly obvious starting position. Assume the House of Commons resolved to allow repayment of travelling expenses for MPs attending the House of Commons living more than 20 miles from London. And I can add words here, on a trial basis. All applications were to be considered on personal application made before the whole House. An MP stands up in the House, asks for repayment of his recent expenses for travelling to London, producing for the Speaker a bogus receipt from the travel company, or the alternative, merely making the false claim, unsupported by documents. In fact, the MP had been staying in London at all material times. The application is granted by a show of hands. The ayes have it. The truth is then revealed by a daily newspaper alleging that the MP had committed a criminal offence. Does parliamentary privilege apply? The applicants submit that the answer can only be yes, and this was accepted by the Crown. The Court of Appeal, in paragraph 74, said merely that the statement might be immune from suit. Again, with respect, it must be so, or at least should be so, because it's dangerous to start examining statements on the floor of the House. And this is the example we're postulating here, and to say that statement A is protected by privilege because of the freedom to take part in debating, the making of laws or similar core activity, but statement B is not so protected because it merely relates to the remuneration of MPs or to a claim for expenses by a particular MP, or a statement to protect an MP's personal reputation. You Lordships may recall the reference to the sword of truth that was referred to by a former minister.
Once you have a statement which is made to the House, isn't it by definition then part of the core business of the House? The House is going to, it obviously one would assume was an important matter if it's got to be made to the House, and the House has got to debate it. And the same might be said of Sir Thomas Legg's report. It was actually designed to be a report making recommendations for consideration in the House, no doubt, if the recommendations hadn't been adhered to, if MPs had refused to repay. But I think, you're going to come on to the next steps in the argument, but the next steps in the argument leave aside the statement to the committee, which is, I think you will say, with some forces in the same category as statement to the House. But the final step becomes, at some point, purely ministerial. The House is no longer interested. We've entrusted this. This is just a matter of mechanics, and nobody is ever going to debate it or consider it a matter of importance for us. Isn't there a distinction?
No, my Lord, there's no principled distinction. You haven't drifted from proceedings in Parliament to not proceedings in Parliament. That's the only phrase we're looking at this stage. It's to say that because it's become formulaic, because it's become regular, because it's become delegated, does it cease to be part of proceedings? We say no, and that's why we have this descending order. It's important to go through it in order to make sure that one doesn't trip up at it's to the committee, or it's in writing, or it's to a subcommittee. It's where do you stop? And we say if you include the Legg review, even though the Lordship has correctly described it as a process that arises out of a problem, the Commissioner for Standards is, of course, a regular, almost permanent sitting part of the administration of the House, and we say the Fees Office itself is no different in principle.
Is there an analogy then between what we're talking about here and declaration of interests? Because it used to be the practice, certainly in the House of Lords, for people to declare their interests when they got to their feet and said something.
Yes.
But a kind of bureaucracy has grown up whereby everybody's expected to do that on paper, and it's all bound up in a volume, and I suppose it's not so necessary to do it in person in the House. But you would say that privilege applies to both the written declarations and the oral ones?
It's central to our argument that as soon as you go out of the chamber, out of the committees, into Sir Thomas Legg's review or into the Register of Members' Interests, recommended in the 1990 review to be part of proceedings in Parliament, then there's no principal basis upon which you exclude the allowances scheme, which itself is central to the performance of the MP's function. That's what it's there for, and is no different in principle, we say, from the Register of Members' Interests.
The Register of Members' Interests, though, is the background to everything that happens in the House or a committee. And at the beginning of committee meetings in the House of Lords, the practice was to say it exists, but if there are any specific interests, they'll be declared now. And it's quite different, isn't it, from fees? You can't say that whether or not a member has claimed allowances to arrive in the House is the background to what's going on in the debate.
Lord, I can and do, and that's what we say, that the whole purpose for creating the allowance scheme is to ensure that members of Parliament are capable of discharging their duties, their function as MPs. And that's why we go down through this process. And if at one point the court says, well, that committee is included, but that isn't, one, because the Register of Members' Interests is different for this reason, then we say your Lordship will be falling into error, because the process is to deal with proceedings in Parliament in a more generic sense. And that's why we give the example of what if the claim by the Member of Parliament is put direct to the committee. And that shouldn't make any difference either. And the Legg review is merely a useful example of how the submission of the document is not the touchstone. It's whether what you are submitting it to that's important. I'm repeating myself. I also realise we've got past 1 o'clock.
Yes.
Lord, I'd hoped to finish by 1 o'clock. I've got another 20 minutes, I expect. You're enjoying yourself, right? Time passes when you're enjoying.